Hey everyone, and welcome to this explainer. Today, we're unpacking a piece of South African legal history that is deeply emotional, incredibly complex, and just fundamentally important. We're going to be looking closely at Constitutional Court Case CCT 1498, which centers around a man named Laurie John Fraser. So let's dive right into this. You see, this isn't just some dry, dusty legal dispute. No, it's a landmark battle about family, about our procedural rights, and above all else, the irreversible passage of time.
Now, I really want you to keep this one question in the back of your mind as we go through today's explainer. Can a father take on the entire legal system, successfully fight for a constitutional right, literally change the law of the land, and yet, at the very end of it all, still lose the child he was fighting for? It's a heartbreaking paradox for sure. But to understand how such a seemingly contradictory outcome could even happen, we really have to look at the exact facts of Mr. Fraser's multi-year legal battle.
Section 1. A father's legal battle. The fight for custody and recognition.
So at first glance, the folks involved in this case seem pretty ordinary. You've got the applicant, Mr. Fraser, who is the unmarried father of a little boy. You have the first respondent, Miss Adriana Petronella Naude, the child's mother. You've got the second respondents, who are the adoptive parents. And sitting squarely in the middle of this incredibly intense adult conflict, you have a baby boy. We need to look at all these players neutrally, right? Because this case fundamentally tests how the law handles competing, deeply personal interests when a relationship breaks down.
Well, things unfolded rapidly in the Children's Court in Pretoria North. Step 1. Ms. Naude, the mother, places the child up for adoption. Step 2. Mr. Fraser actively tries to intervene. He opposes the adoption, and he actually applies to adopt his child himself. Step 3. Ms. Naude flat-out refuses to give her consent to Mr. Fraser's application. And since the court didn't find her refusal to be unreasonable, Mr. Fraser's application is completely dismissed. Finally, Step 4. The mother consents to the adoption by the adopted parents, and the Children's Court grants it. And just like that, the legal ties between the biological father and his son are completely severed.
Section 2. The unmarried father's disadvantage. The law as it stood in 1983.
The whole root of this conflict really comes down to Section 18.4 of the Child Care Act 74 of 1983. Under the law as it stood back then, if a child's parents were unmarried, the mother was the only person recognized by the law as having the right to consent to an adoption. If she said yes, the adoption went ahead. The unmarried father, well, his consent was entirely legally irrelevant. It wasn't required at all. It's just a massive absolute legal imbalance.
Now, it's really important to point out that the Children's Court wasn't acting maliciously here. They were just following the strict requirements of that Child Care Act. By granting the adoption to the second respondents, the court implicitly found two very specific things that the act required. First, that the adoptive parents were of good repute and fit to be entrusted with custody, and second, that the proposed adoption would serve the interests and conduce to the welfare of the child. Basically, in the eyes of the Children's Court, this child was going to a safe, loving home.
During this massive legal struggle, the High Court actually appointed a curator ad litem. Now, if you aren't familiar with the term, this is a legal representative appointed by a court specifically to represent a child's best interests during litigation. And what you should really take away from this is a pretty striking detail from the case history. The very official appointed to protect the child's interests actually opposed Mr. Fraser's review application and supported the adoption order. So the child's own legal representative felt the adoption was absolutely the right move.
Section 3. A bittersweet constitutional victory. Winning the battle, losing the war.
And this is where history is literally made. Mr. Fraser takes his challenge all the way to the Constitutional Court. He argues that Section 1844D of the Child Care Act completely discriminates against unmarried fathers. And guess what? He wins. He successfully proves that the law, exactly as it stood, was unconstitutional. It is a monumental, game-changing victory for unmarried fathers across the country, fundamentally changing the landscape of South African family law forever.
But there was a massive caveat. And this is exactly why this explainer is about the paradox of justice. You see, the Constitutional Court agreed the law was unconstitutional, but they suspended their order for 2 whole years. Why? Well, they had to give Parliament time to rewrite the law in a way that wouldn't suddenly invalidate thousands of already completed adoptions across the entire country. The court had a really good reason to do this for the sake of national stability. But for Mr. Fraser personally, it meant his victory provided him absolutely no immediate relief. The old law still governed his specific case.
Now, alongside his constitutional challenge, Mr. Fraser was also fighting the adoption procedurally, basically arguing he didn't get an adequate hearing. The whole legal system turned into this exhausting ping-pong match. First, he loses in the Children's Court. Next, he fights all the way up to the Transvaal High Court and actually gets the adoption set aside on review. But then, the adoptive parents appeal that, and the Supreme Court of Appeal overturns the decision, upholding the original adoption. So Mr. Fraser is now applying for special leave to appeal to the Constitutional Court one final time.
Section 4. The passage of time, when the slow wheels of justice conflict with a child's rapid growth. 3. That is literally the most important number in this entire case, because by the time this final application reaches Judge Chaskelson P. at the Constitutional Court, almost 3 whole years have passed since the original adoption order was made. Just think about that. 3 years of court filings, appeals, hearings, and judgments.
Judge Chaskelson P. actually acknowledges that Mr. Fraser isn't to blame for this delay, but the court simply cannot ignore the passage of time. The judge states powerfully, "Continued uncertainty as to the status and placing of the child cannot be in the interest of the child." And this tells us exactly where the Constitutional Court is focusing its attention. Not on the rights of the adults, but on the boy.
Because, the reality on the ground was stark. While all the adults were debating constitutional law in the highest courts of the land, a little boy was growing up. For those 3 years, basically since birth, he was brought up by the adoptive parents. He knows them as his parents. Their family is his family. And he has had absolutely zero contact with Mr. Fraser. The child is just completely oblivious to the massive constitutional drama surrounding him. He just knows his home.
Section 5. The child's paramount interests, the ultimate legal trump card. So even if the court granted the appeal, and even if Mr. Fraser eventually won, it would really just mean the adoption proceedings would have to be reopened. The whole dispute would drag out through the courts all over again. The court lays out its pragmatic logic very clearly here. The child only knows this adoptive family. Reopening the case literally guarantees prolonged uncertainty. And ultimately, finality is required. All parties have suffered, absolutely, but the matter just must end.
The absolute legal bedrock for this decision lies in Section 28(2) of the 1996 South African Constitution. It states that a child's best interests are of paramount importance in every matter concerning the child. Not just important, paramount. It overrides literally everything else. This constitutional provision ultimately overpowered Mr. Fraser's claims about administrative justice and procedural fairness. The child's well-being was, without a doubt, the trump card.
With that powerful reasoning, the Constitutional Court summarily dismissed Mr. Fraser's application for special leave to appeal without making any order as to costs. 10 judges, including Sachs, Lange, and Kriegler, all concurred with Judge Chaskelson P's judgment. And with a stroke of a pen, this grueling, multi-year legal saga was brought to an absolute, definitive end.
Which leaves us with this final thought. We've seen how a father fought the system, actually changed the law for everyone, but lost his own personal battle because the clock just kept ticking while the courts deliberated. So when the slow wheels of justice conflict with the incredibly fast growth of a child, who should pay the price of time? It's a profound legal reality that leaves us asking what true justice actually looks like when family's on the line. Thank you so much for joining me for this explainer.